Okay, so there was a concern about what the sale of securities is, why you need to be concerned about this, why you want to worry about this. And so the reason why I'm doing this little presentation is to show you the different ways that when you think you're not selling a security, you can still get in trouble for going out, looking for investors, advertising, and then not providing proper disclosures or doing the proper filings for those investors. So here is an example, and this is from the state of Ohio. And in this, respondents are involved in the rehab, sale, and management of real property for investment purposes. Respondents solicited individuals to invest in promissory notes, which were to be secured by real estate. And the respondents used the term private lenders to describe note holders. So this is very familiar to most of you out there. That's what you're doing. It doesn't matter if you call it a note or a JV or anything like that. It's all the same. It's still a security. You still have to follow securities laws. They advertised the notes. The respondents also represented that the notes were guaranteed, low risk, safe, and secure. This wasn't part of the conversation, but I want to tell you never to use these 4 words when describing an investment opportunity to an investor. Guaranteed, low risk, safe, and secure. Those are all bad words to use. Please don't ever use them, because these folks were ordered to cease and desist from ever selling securities again. Or until they made a registration or had a proper exemption. So, and this cease and desist will follow these folks around on the internet for as long as the internet exists. Now, let's take a look at some other cease and desist orders. This is an old book I wrote from a couple years ago, and so we look in the middle here. And I'll expand this. And here's that test again that I talked about in the comments. The test from the Securities Act called the Howey test. Is there an investment of money? Is there an expectation of profits? Are you the promoter that is raising the money, and is all of the money being used for the same particular purpose? So even if you put one investor per property, the same particular purpose is your real estate investment business. So you want to be very careful with that. So here's another cease and desist order. This is from the state of California. And this is another real estate company. And this is, they offered and sold securities from unsecured interest-bearing notes entitled Straight Interest-Bearing Note to Residents of California. And it was this is basically the same situation. The funds would be used for investment by Word Real Estate while failing to disclose that a significant portion of investors' money was going to be used for personal expenses. Okay, obviously you don't want to be doing any. Okay, so then some of you were talking about joint venture agreements. And here is exactly one this is from the state of Mississippi. Look, I'm showing some, random examples of these cease and desist orders, but quite frankly, they're all the same. This one talks about joint venture agreements, and where the joint venture agreement was entered into by 2 partners. And they called it an investment contract, and they entered into a variety of different joint venture agreements. Again, we're seeing those words: low risk, safe, and secure. To avoid Registrar's investment contracts as securities, Sunshine attempted to structure the investments as real estate joint ventures and assigned each general partner a specific interest in a specific lot covered under the joint venture agreement. So the Securities Commission said that the joint venture agreements are in reality investment contracts, in that the Mississippi investors had no functions or responsibilities following their initial investments, again, through the efforts of a promoter. So there you go. So whether you're selling a note or a joint venture, if you fit the Howey test, those 4 prongs of the test: investment of money in a common enterprise, through the efforts of a promoter with the expectation of profits. If you answer yes to all of those, then you are selling a security and you need to make proper disclosure. I hope you found this helpful. My name is Jillian Sidoti. If you need more information, you're welcome to email me at Jillian, JILLIAN, at syndicationlawyers.com, or you can just find me on Facebook. Thanks. Have a great night.